Singapore enforces some of the strictest animal welfare regulations in the world. A first-time offender found guilty of animal cruelty faces up to 18 months in prison and a fine of 15,000 Singapore dollars. The state manages a dense administrative framework. Under the 2024 licensing and control rules, all pet dogs must be microchipped, and ownership in public housing is strictly limited to one approved small breed per apartment. This extensive record apparatus functionally treats dogs as feeling creatures whose daily physical and social welfare requires strict government oversight. But if you search the primary legislation driving these rules, the Animals and Birds Act 1965, for the word sentience, you get zero results. The statute does not explicitly state that the animals it protects can actually feel. Legal researcher Bert identifies this statutory silence as a structural deficit. The law fails to name the very capacity for suffering that it is designed to penalize. By heavily regulating animal welfare without explicitly defining what an animal is, the state forces its legal system to operate on an implicit assumption rather than a firm conceptual premise. A pragmatist might argue that if cruelty is already actively punished, the exact wording of the statute shouldn't matter. The reality of animal welfare enforcement is quite different. The Animal and Veterinary Service, or AVS, faces severe evidentiary hurdles in its investigations, relying heavily on direct physical evidence of injury or witnesses willing to testify. This creates a legal blind spot for psychological abuse. Conditions like chronic fear, severe social deprivation, and environmental monotony leave no visible scars to photograph for a courtroom. Without an explicit statutory declaration recognizing an animal's mental state, prosecuting non-physical suffering is conceptually strained under the current text. The omission forces prosecutors to rely almost entirely on administrative discretion and judicial interpretation to hold abusers accountable for psychological harm. Historically, animal law relied on the pathology test. This is the primitive legal assumption that unlawful suffering only exists if visible physical injury or illness can be proven. Singaporean courts began dismantling this assumption in the 2013 district court case, Public Prosecutor v. Ling Chung Yi Roy, which involved a border collie confined to a balcony for prolonged periods. Judge N. Peng Hong officially rejected the pathology test. He ruled that unnecessary suffering is not dependent on whether the dog is physically sick or visibly injured. The jurisprudence evolved further in the 2025 High Court appeal, Public Prosecutor v. Lin Peng Li Berry, a case involving severe cruelty to cats. Here, the High Court explicitly categorized the protected animals as a vulnerable class of victims entirely under human control. Looking at the transcript, the judge specifically described the victims as sentient creatures. Singapore's judiciary is already deriving sentience and recognizing psychological suffering through its rulings. They are doing so while the primary statute continues to lag behind. The scientific consensus on animal cognition has already arrived at this conclusion. The 2024 New York Declaration on Animal Consciousness formally states there is strong scientific support for conscious experience in mammals and birds. Dogs serve as the strongest defensible paradigm for integrating this science into Singapore's specific legal reform. A foundational 2002 study published in the journal Science proved that domestic dogs possess unique social cognitive capacities, selected through generations of domestication, enabling them to read human communicative signals. Furthermore, a 2024 neuroimaging review confirmed that dogs possess highly mapped brain regions directly implicated in face, body, and emotion perception. This diagram illustrates the 2020 5 domains model, which is the standard framework for translating biological needs into welfare science. It measures data across 4 physical pillars: nutrition, environment, health, and behavioral interactions. The model proves an animal can be severely harmed without physical mutilation. It calculates subjective experiences from those 4 domains, synthesizing them into a final assessment of the dog's mental state. This provides evidentiary discipline for the law. It removes guesswork, allowing investigators to assess chronic distress using structured environmental and behavioral metrics. Psychological suffering is not subjective legal philosophy. It is an objectively provable state derived from established, measurable data. The primary institutional friction blocking statutory reform is the slippery slope fallacy, the fear that acknowledging an animal has a mind automatically equates to granting it full legal personhood. Critics argue that recognizing sentience will dismantle property law and eliminate public safety controls over animals. International comparative law proves this false. Article 13 of the Treaty on the Functioning of the European Union explicitly recognizes sentience while successfully maintaining agricultural economies and cultural customs. This legal spectrum is managed carefully elsewhere. The UK's Animal Welfare Sentience Act 2022 and New Zealand's 2015 amendments serve as models of scrutiny. These international models utilize sentience merely as an interpretive governance principle. They do not draft a human rights code for pets. Explicit sentience recognition is legally orthodox. A state can easily maintain strict regulatory control and ownership rules while demanding objective, scientifically backed welfare standards. Applying this to the specific mechanics of Singapore's Animals and Birds Act requires a precise approach. There is no need for an overly ambitious, whole act redefinition that might trigger unintended constitutional consequences or disrupt routine administration. Albert Tan's surgical solution is to insert a targeted welfare principles clause exclusively into Part 4 of the Act, which houses the central cruelty provisions and duty of care. This clause legally mandates that administrators and courts must consider the physical and psychological welfare of the animals protected by that part, including their capacity to experience pain, distress, and other adverse welfare states. The direct impact is immediate. It updates the statutory duty of care and removes the need for prosecutors to constantly relitigate the definition of suffering in every case. This targeted amendment bridges the gap between the operational reality of AVS enforcement and the conceptual void in the primary statute. The policy window for this change is currently open. The Ministry of National Development is conducting a comprehensive review of the Act, aiming to begin public consultation on a draft bill around the end of 2026. Tan's proposal aligns directly with Recommendation 3 of the 2025 SPCA Acres White Paper, which specifically calls for introducing principles based on the physical and psychological needs of animals. This legal modernization connects directly to the broader national goals of the Singapore Green Plan 2030, specifically its city and nature pillar, aiming to raise animal health and welfare standards. Public safety and animal sentience are not rivals. The state can enforce strict muzzling, licensing, and insurance rules, while legally acknowledging the regulated animal's capacity for chronic distress. Updating the statute to explicitly name what the law already knows does not make Singapore's legal framework eccentric. It makes it empirically, scientifically, and jurisprudentially accurate.